your lawyers will be able to speak more specifically to your personal situation. You can think of the litigation process as a journey, consulting a map to take the best route, and following laws and procedures to accomplish your goal of arriving at your destination with your attorney as your navigator.
The word litigation scares a lot of people, but it shouldn't. The civil justice system is not perfect, but it does strive to ensure the just, fair, equitable, and impartial consideration of every lawsuit. It's written right into the rules that way. The system is designed to allow you to tell your side of the story.
The main steps in litigation are pleadings, discovery, motion practice, mediation, trial, and appeal. During the first phase, pleadings, a complaint, sometimes called a petition, is filed with the appropriate court on behalf of the plaintiff, the person suing. The complaint typically involves an injury, which may be physical, but more commonly involves money, property, or quality of life. The defendant, the person being sued, is then notified that a complaint has been filed against them, commonly called being served. The defendant must then file a response to the complaint called an answer, admitting or denying the allegations. During the next phase, discovery, you and your lawyer gather information about the case. Evidence from each side of the case is made available to the other side. This helps each side prepare for evidence that may be presented in court and helps them to evaluate settlement opportunities. Motion practice is how each side communicates to the court, asking for rulings on issues before trial. Most cases are actually resolved before reaching trial through arbitration, mediation, or settlement when each side is willing to compromise to some degree through their lawyers or an outside mediator. If a settlement is not reached, then the case proceeds to the trial phase. The judge acts as an impartial overseer, ensuring that the law and correct procedures are followed in the trial. During the trial, the lawyers argue the facts of the case before the judge or jury, calling witnesses and presenting evidence. Then the jury deliberates, or the judge considers the evidence and a verdict is reached. In some cases, money or property is awarded. In other cases, the judge may order one or more of the parties to do or refrain from doing a particular act. You may have heard about appeals in the news where verdicts or judgments are overturned. Appealing is an option if either side is not satisfied with the outcome, but it is costly and time-consuming and should be thoroughly discussed with your lawyer.
But your job is to make the final decisions about how we handle your case.
Ooh, that sounds a little scary.
Well, don't worry, I'll be there for you every step of the way.
Okay.
In this regard, it's just very important that you always be sure to tell me the truth. The whole truth, good or bad.
Okay.
I can handle it, okay?
And I can do that.
Okay. It's the only way that I can be sure that I'm giving you the right advice. Mm-hmm. Think of it like going to your doctor, okay? If you go to your doctor and don't tell him or her what's ailing you, they're going to find it a lot harder to help you, and they may even get it wrong. Now, also along the way, you're going to be providing information and documents. Now, it may seem to you that some of the things I ask for are highly personal or even irrelevant, but it's all part of the process of getting your story out, okay?
Okay.
So just like telling the truth, you shouldn't hide any documents from me.
I won't do that, and I don't have a problem with that at all.